Is Donald Trump being robbed? Hi, my name is Adam Berkey. I'm a former police officer here in Southern California. I'm familiar with the judgment against Donald Trump and his family for disgorgement because the government in California did something similar to me in 2017. I was fined nearly $1 million for not having a professional license, even though I had one, and the maximum fine allowed was $5,000. The term disgorgement was used to conceal egregious abuse of authority and punishment in an attempt to financially destroy me. Like in Trump's case, the government lied and said disgorgement wasn't a fine, that I wasn't being punished, that it was an equitable remedy. And just like in Trump's case, the government denied me all the heightened constitutional protections required in criminal proceedings. As a result of what happened, I commenced a multi-year investigation and discovered disgorgement is a theory of law that's being egregiously abused by judges around the country to steal people's money, property, and liberty under color of law but without lawful authority. I'll be releasing a documentary about my investigation called Treason by Judge very soon. If you'd like to be notified when it will be released, please visit my website, thespiritoflaw.com, to add your email address. I want to be clear about something up front. I'm not interested in politics as that term has come to be used to mean committing fraud, treason, and crimes on the American people and opposing political candidates. I'm interested in the truth and the fair and impartial administration of justice, so that's what I'll be sticking to here. I hope you won't allow any biases you may have to dismiss the actual evidence. There's only one question to ask when the government uses the force of the legislative, executive, or judicial power to take away someone's money, property, or liberty. That question is, by what authority? By what authority did the Attorney General bring this case? And by what authority did the judge proceed to trial and order the requested relief? As a preliminary issue, the question, by what authority, is a mandatory non-discretionary question that must be asked by every official before taking any official action. In a court case, it goes to the fundamental authority of the judge to even hear the case and has nothing to do with whether the accused is innocent or guilty. The judge cannot even proceed to the issues of the claims or charges if there's no authority to hear the case to begin with. The only difference between a government official taking your money, property, or liberty by law or not is whether that official had lawful authority. It is just as much the crime of robbery to use the force of the executive and judicial power of a state and its armed police force to steal property as it is for a robber to steal money from a bank. New York Penal Law Section 160 defines robbery as forcible stealing. The New York penal statutes further state that it is robbery in the first degree, a Class B felony, if during the commission of the crime the person is armed with a deadly weapon or threatens the use of a dangerous instrument. I hope there's no question about whether the Attorney General bringing these claims and a judge ordering millions of dollars to be paid constitutes a forcible taking. I've taken a look at this case and have yet to find any lawful authority for the judgment order. Some of you might want to make this about your feelings toward Donald Trump and whether he made false statements or not to save on loan interest. You're welcome to those perceptions, but he has a right to judicial proceedings and a full, fair, and impartial trial in the first instance. Based on my investigation thus far, this is not even remotely happening here. I'm going to show you why and with evidence available to anyone willing to look. If I rob a bank and get caught, the law requires me to make restitution by returning the money to the bank because I took something that didn't belong to me. This form of relief is called restitution. The injured party is compensated by being restored to their position before the crime took place. If, in addition to restitution, the state punishes me by ordering that I pay a fine to the state for breaking the law, that's something else. It's a penalty. It's punishment. It's not restitution. In this case, Arthur Engeron, the judge, ordered the money that would otherwise be due to the purported bank victims under the theory of restitution to be paid to the state of New York. What lawful right does the state have to this money if the banks were supposedly defrauded? The state has no more right to this money as restitution than you or I do. If either of us went to the court and demanded this money as restitution, we'd be thrown out. So then why did Engeron award all this money to the state of New York? Is it still called restitution if the money isn't paid to the victims to compensate them for harm? If the state never lost anything, how could it be considered restitution for the state to get the money? Unless it isn't restitution. it's something else. The big lie. How the term disgorgement is used to conceal a penal forfeiture as an equitable remedy to steal money, property, and liberty. Let's look at what the statute involved says to see what authority it actually gives the Attorney General and the judge. It's Executive Law 63:12. Whenever any person shall engage in repeated fraudulent or illegal acts or otherwise blah, 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 the Attorney General may, not shall, apply in the name of the people of the state of New York to the Supreme Court blah, blah, blah for an order of any fraudulent acts directing restitution and damages. So the next question we have to ask is, did Letitia James ask for restitution or damages? Let's look at the complaint. Here's what's called the prayer for relief. It means the relief the plaintiff is asking the court to award in their favor. I wasn't able to find any prayer for restitution or damages. What I found was this. We'll get into what disgorgement is, but first, let's see Judge Engeron's order to see whether this is what he awarded or not. Engeron made two separate orders regarding the 7 claims made by Attorney General James. The first was an order granting summary judgment on the first claim before trial. No money was awarded in that judgment. The second was an order issued after trial on February 16, 2024 for disgorgement. Here's how Engeron explained disgorgement on pages 81 to 82 of the order. He said, disgorgement is distinct from the remedy of restitution because it focuses on the gain to the wrongdoer as opposed to the loss to the victim. Well, right there, it seems we might have a serious problem. Remember, the statute only authorizes restitution or damages. Here, Engeron is ordering disgorgement, which he admits is distinct from the remedy of restitution. What's more is this doesn't seem to be restitution if the money is being paid to the state and not the purported bank and insurance victims who, mind you, were never even made parties to the case despite being the real parties in interest to any restitution claims. I searched for the term disgorgement in New York statutes to see if the legislature had defined it anywhere or used it in a certain context that might apply here. There were no results. I then researched the legislative history of 6312 by first obtaining the bill jacket, which is available online at the source in the bottom right-hand corner of this slide, as well as making Freedom of Information law requests to the New York Assembly and the Senate. The point was obviously to see what the legislative intent was, if disgorgement was ever contemplated, let alone intended by the New York legislature and governor, who purportedly enacted the statute. There have been numerous amendments to Section 63. Some don't apply to subsection 12. The ones I researched that do apply, I've made red for quick reference. The ones that are pertinent to this issue are when the remedies of restitution and damages were added to subsection 12, because they weren't initially part of the statute. Let's look at these specific amendments. Before doing that, I want to mention that I noticed Engeron discussed the legislative history of 6312 at the beginning of his February 2024 order. But curiously, he left out the information of the amendments that involved adding restitution and damages. I wonder why he left these parts out. The First Amendment is known as Chapter 44, Laws of 1970, pertaining to restitution. It says, an act to amend the executive law in relation to authority of the Attorney General to seek restitution in certain proceedings. I started by checking out the definition of restitution in Webster's Dictionary of 1828, which I've heard was adopted by the U.S. Congress as the official dictionary for the meaning of words and phrases in the U.S. Constitution. If you have the congressional record pertaining to this adoption, please send it to me. It says, restitution is the act of returning or restoring a person something or right of which he has been unjustly deprived. Restitution is made by restoring a specific thing taken away or lost. It clearly doesn't use the word disgorgement, and it doesn't say anything about restoring or giving up anything to anyone, including a state which it never lost. It also doesn't include the words punishment or penalty. In comparison, when we look up disgorgement, it has nothing to do with any remedy at law or equity, or giving back anything to someone that was unlawfully taken. It says here, disgorge, to eject or discharge from the stomach, throat, or mouth, to vomit, to throw out with violence. Disgorgement, the act of disgorging, vomiting. You see, this is what some judges do to manipulate, control, gaslight, and commit fraud, treason, and other crimes upon the American people. They just make up words and phrases to fit whatever their agenda is in the moment. Maybe Donald Trump should eat some bad sushi, barf it up in a plastic bag, and deliver it to the Attorney General as satisfaction of the judgment. In the bill jacket, I also found a letter from a former Attorney General to the Governor pertaining to the amendment authorizing restitution, explaining his intent and urging its passage. In his letter to the Governor, the AG stated, "Nevertheless, the questions raised as to the authority under the subdivision to obtain this additional relief of restitution, not disgorgement, for the benefit of the defrauded consumer, not the state, are unsettled, and it is necessary in the public interest that the statutes spell this out specifically and remove any doubt so that all parties involved may be informed as to the relief available under the consumer fraud provision above referred to. The courts may, thus, as an incident to the injunctive relief, direct the return of the fruits of the wrongful practices." It clearly says for the benefit of the defrauded consumer and return of the fruits of the wrongful practices. In this case, that would appear to be the banks and insurance companies, not the state of New York. The word restitution used by the Attorney General seems to align perfectly with the Webster's definition of restitution. To be clear, these documents, contemporaneous to the statutory enactment, are not the comments of the legislature per se, but those of other officials and entities interested in the bill. Because they are contemporaneous, they indicate what the understanding of the words and phrases and intent was at the time of the statute's enactment around 50 years ago. Let's see what else was in the bill jacket. Here we have a budget report on bills. The subject and purpose states, "This bill would authorize the Attorney General to seek injunctions requiring repayment of losses arising from fraudulent business practices." In another part, under arguments and support, it says, "Existing law does not specify the Attorney General's authority to request this relief for a defrauded consumer." Again, the contemporaneous understanding is that the statute authorizes repayment of losses and relief for defrauded consumers, not windfalls or penalties payable to the state of New York or any third party. The Association of the Bar of the City of New York also had some very relevant input. It said, "We note that there is no specific provision with respect to the manner in which the restituted funds shall come to rest in the hands of the defrauded consumers. Presumably, this will not be a problem, yeah, right, in the case of the complainant who prompted the action by the Attorney General. But since the statute contemplates a repeated course of prohibited activity, there will usually be additional defrauded persons entitled to a portion of the recovery. Since the names of the other defrauded persons will frequently be brought out at the hearing, we assume this problem of restitution will be handled as in the case of a class action, and that in administering this statute, the Attorney General and the court will notify other defrauded persons and afford them an opportunity to recover the amounts belonging to them." Again, nothing about penalties to the state or the state keeping the money due victims or defrauded consumers. Next, we have the New York Lawyers Association. This amendment would authorize the Attorney General to seek an order directing restitution to victims of business frauds. However, victims of such practices must obtain redress through private actions for restitution. This proposed amendment would enable the Attorney General to seek restitution on behalf of these victims. Although no one I'm aware of is contending the so-called judgment is for damages, I also examined the legislative history of Chapter 539 of the laws of 1977, an act to amend the executive law in relation to authority of the Attorney General to seek damages in certain proceedings. By no coincidence, one of the issues raised in this amendment is what was intended by the word restitution. The first document appears to be a legislative summary. It says, "Rationale. Intended to clarify intent of statute by providing that damages can be sought due to some question over the scope of restitution allowed in the present statute." In the second paragraph next to pertinent considerations, it says, "Present law allows the Attorney General to seek restitution. The word restitution has been defined to include compensation for damage, loss, or injury. In recent litigation, since the authority to direct restitution was inserted in Subdivision 12, this broad meaning ascribed to restitution has been questioned. Next, we have a memorandum written by an unknown source. It says, "What was intended by the word restitution, and will be accomplished by the phrase restitution or damages, is to authorize the court, in appropriate cases, to award statutory or compensatory damages. Many consumer protection statutes provide for the award of specified sums of damages, and many occasions arise in which a simple refund of monies paid does not adequately compensate the victim. It is a narrow reading of the word restitution which would preclude awards in such cases, which this amendment would avoid. No power to claim or collect punitive damages would be given by this bill." Once again, the apparent intent is toward compensating victims with statutory or compensatory damages and not penalties such as punitive damages. Again, no mention of the word disgorgement or penalties payable to the state or third parties, not just here, but anywhere else in the bill jacket. A few days ago, on March 28th, I received a Freedom of Information request response from the New York Senate. Included in the documents were 2 pages that had a comment from then-Governor Nelson Rockefeller made contemporaneous with his passage of the amendment to 6312 to include restitution. I located the actual memorandum in the bill jacket of Chapter 33, Laws of 1970. Here's what Rockefeller said. "The power to obtain restitution will aid in protecting consumers to undo the fruits of past fraud, as the power to enjoin will be effective against future fraud. These powers granted the Attorney General under these bills will afford a practical means of halting consumer frauds at their incipiency without the necessity to wait for the development of persistent frauds as required under existing narrow statutes, and will provide a means to make the victims of past fraud whole again." Once again, there is nothing here even remotely indicating that the governor passed the bill with the intent that it was to be used to order disgorgement or penal forfeitures against defendants payable to the state or other non-victim third parties. So where's the authority to order hundreds of millions of dollars in disgorgement? Maybe you can tell me, because I can't find it anywhere in the statute or the legislative history. Some might claim it's in the court's inherent equity powers, but I don't buy it. I think that this case was what the New York Constitution refers to as a new class of actions or proceedings, otherwise known as a special statutory jurisdiction. Engeron was consequently bound to strictly construe the statute, not exercise the legislative power of New York to expand his power. If disgorgement as used by Engeron isn't restitution, then what is it? I'm convinced it's a penal forfeiture that was not authorized by the statute, nor ever intended by the legislature. Because there is no apparent lawful authority to render the judgment, any exercise of dominion or control over the defendant's property, including the judgment itself, potentially constitutes fraud, robbery, treason, and a host of other state and federal crimes, including racketeering. And it potentially subjects Engeron and James to counterclaims for damages for deprivation of rights under color of law. No one has immunity to violate the New York or U.S. constitutions, no matter how absolute they may believe their immunity to be. I believe the judgment is an egregiously unconstitutional penal forfeiture, not restitution or equitable disgorgement, because the forfeiture was not only not authorized by statute, the proceeds were ordered to be paid to the state, not the banks, who would purportedly be the real parties in interest to a claim for restitution or unjust enrichment. They, however, were never even made parties to the action. I also have a serious problem with how violations of numerous penal statutes were used in other claims under 6312, yet none of the heightened protections in criminal proceedings were afforded, including the right to trial by jury. Each of these issues appear to be fatal to the judgment, rendering it entirely void because both the New York and U.S. constitutions were violated. A judge can't claim to have subject matter jurisdiction or authority to violate a constitution when the Constitution withholds and forbids authority to do that thing. Another way of saying this is you can't commit a crime to procure or maintain authority over a case to steal someone's money, property, or liberty. As the justices said in the case of Cohens versus Virginia, we have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution. Because of the fact heinous crimes and violations of judicial process appear to have been committed to procure and maintain subject matter jurisdiction, the case would seem to be over and can never be revived against any of the defendants. If a judge acts without authority, his judgments and orders are regarded as nullities. They are not voidable, but simply void, and form no bar to a remedy sought in opposition to them, even prior to reversal. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. If it were me, I would be filing a crime report at the NYPD against Angeron and James. This concludes part 1 of my investigation. In part 2, I'm going to trace the history of when the New York Attorney General's office began seeking disgorgement and when the judges began authorizing it to pinpoint the case where this egregious abuse of authority began. In the meantime, you might want to research what a bill of pains and penalties and ex post facto law are, as found in Article 1, Section 10 of the U.S. Constitution. To my knowledge, the U.S. Supreme Court has never fully defined what a bill of pains and penalties is, but you can find an attempt by a dissenting justice in the case of Ex parte Garland. I interpret it to mean the imposition of punishment by a state official without a judicial determination of rights, or in other words, without lawful authority. As far as an ex post facto law is concerned, consider the case of Calder v. Bull. I've carefully not included any claims pursuant to the 14th Amendment because it was never lawfully ratified. Just read the Utah Supreme Court case of Diet v. Turner. You can't put people under martial law rule to force them to ratify an amendment in violation of Article 5. Now then, if there was no authority to render a judgment in the first instance, how could you possibly be responsible to pay a bond for an appeal? Isn't that some type of extortion? And if you did need an appeal, why in the world would you pay a bond instead of filing a free lawsuit against the state and the rogue officials directly in the U.S. Supreme Court, to the extent it's not a kangaroo court itself? Article 3 of the Constitution declares that in all cases, that's ALL, in which a state shall be a party, the Supreme Court shall have original jurisdiction. Here it is, straight from the mouths of the justices, once again in the case of Cohens versus Virginia. The Constitution gave to every person having a claim upon a state a right to submit his case to the court of the nation. However unimportant his claim might be, however little the community might be interested in its decision, the framers of our Constitution thought it necessary for the purposes of justice to provide a tribunal as superior to influence as possible in which that claim might be decided. Even Alexander Hamilton understood these basic principles of checks and balances when he said in Federalist 28 that the general government will at all times stand ready to check the usurpations of the state governments. If the people's rights are invaded by either, they can make use of the other as the instrument of redress. But speaking from experience, even though the U.S. Supreme Court's jurisdiction is defined by the Constitution and cannot be limited by Congress, the clerk of the court, Scott S. Harris, apparently believes the contrary and may unlawfully and arbitrarily exercise the judicial power of the United States and throw your case out before it ever reaches the justices. But I'll let him tell you this in his own words so there's no confusion.
We are bound by the statute in terms of jurisdiction. So you can submit something, but what I'm telling you is it's not going to be accepted for filing unless it falls within one of the provisions of 28 U.S.C. 1251.
Did he just commit treason? No. How interesting. The Constitution says one thing, but the statute says something else. I wonder which one is the supreme law of the land. And if by chance you think the 11th Amendment says things that it doesn't say, and that it would bar such a suit, just remember that the states waived any claims of sovereign immunity with regard to the issues in Article 1, Section 10. Not to mention the states themselves, as fictions of law, are incapable of being vested with any attributes of sovereignty and cannot therefore claim any such immunity to override the will of the people. Not to mention, powers delegated don't equal powers surrendered. Please visit thespiritoflaw.com to see my other work and to be notified when part 2 of this video and my other video, Treason by Judge, is released.
No one is above the law. No matter how rich, powerful, or politically connected you are, everyone must play by the same rules.